Welcome back to the Deep Dive. Today, we are absolutely diving into a really crucial stack of documents, the Geneva Conventions of 1949. Our goal in this deep dive is to, really cut through the dense legal text and figure out what these fundamental international agreements actually say about protecting people caught up in wartime.
Yeah.
Coming right after World War II, what were they trying to achieve? And based strictly on the text we've got here, what are the sort of non-negotiable rules and rights they established?
That's exactly it. These aren't just, dusty old rules gathering dust. As the preliminary remarks really highlight, they're a direct response to the sheer brutality of conflict. The aim was to codify humanitarian principles right into international law. And this was driven by, a deep respect for human dignity. They were trying to ensure basic aid and protection, crucially without discrimination, for anyone no longer actually fighting the wounded, sick, prisoners, civilians. It's about drawing a line, isn't it? Even in the chaos of war.
Okay, right. Let's start at the very beginning then. Who do these conventions even apply to? And how are they supposed to, function? What's the most important thing for you, the listener, to grasp about their scope and the key players involved?
Yeah. The key takeaway right up front is understanding just how broad the reach of these conventions is and the crucial role they give to external bodies to kind of oversee things. If you look at Article 2 across these texts, you see they apply not just in declared wars between states, but really critically in any international armed conflict or cases of occupation, even if there's no armed resistance. And what's also really significant is that if one side is a party to the conventions and the other isn't, the party is still bound in how they deal with the non-party. That's provided the non-party accepts and applies the rules, of course. It's not just a club rule,
So you can't just say, oh, they didn't sign it, so rules are off. That's interesting. In Article 3, that pops up quite a bit. That touches on conflicts within a country, doesn't it?
Precisely. For armed conflicts not of an international character, think internal conflicts. Article 3 lays down a baseline. A minimum set of fundamental rules must be applied. This covers things like humane treatment for anyone not actively fighting, and an absolute ban on violence, torture, taking hostages, humiliating treatment, unfair trials. It also mandates that the wounded, sick, and shipwrecked must be collected and cared for. So even in really difficult internal situations, there's this core humanitarian standard the text demands.
That minimum standard, that sounds powerful. But how does anyone actually check compliance in the middle of a war? I mean, who's watching?
That's where the idea of neutral powers and impartial humanitarian organizations becomes really vital. It's outlined in Articles like 4, 8, 9, and 10 in the various conventions. Neutral powers can try to apply the rules by analogy, but the main mechanism is the protecting power. This is basically a neutral country tasked with safeguarding the interests of the parties involved and their protected people. And if a protecting power can't be appointed, impartial humanitarian bodies like the ICRC, the International Committee of the Red Cross, can step in. Their role is absolutely crucial. They have to be allowed to appoint delegates, visit protected persons wherever they might be, and, check the conventions are being applied. The parties must facilitate their work.
And you mentioned finding an interesting detail in Article 7 of GC the Third and 1A. That protected persons can't actually give up their rights under the convention.
Yes, that's a really critical safeguard. It means even if someone under protection is maybe pressured or even tries to renounce their rights, those rights are inherent. They're non-transferable under the convention. It just reinforces that these protections exist regardless of what an individual might say or do under duress. And the text goes further, doesn't it? It explicitly recognizes and respects the special position of the ICRC in providing humanitarian assistance, particularly to prisoners of war. That's mentioned in Article 125 of GC 3rd. Their work isn't supposed to be hindered.
Okay, so that really sets the stage for who is covered and how it's overseen. Let's move to a really specific group. The wounded, sick, and shipwrecked. Looking at the sources, what's the essential concept we need to grasp about protecting these individuals? What are the absolute requirements for their care?
Right. The absolute core understanding here is recognizing that anyone who's out of combat because of wounds, sickness, or shipwreck, they immediately get protected status. And the conventions lay down these really rock-solid requirements for their humane treatment. Article 12 in GCI and GC6 defines who this covers. It's not just soldiers, remember. It includes authorized civilians with the armed forces like war correspondents or supply contractors as long as they have proper ID. The key phrase in Article 12 is they must be respected and protected in all circumstances.
In all circumstances. Yeah, that leaves absolutely no wiggle room, does it?
Exactly. And Article 12 is, I think, particularly powerful because it doesn't just stop at a general call for humane treatment. It gives a specific, quite frankly shocking, list of acts that are absolutely prohibited against these protected people. Things like attempts on their life, violence, murder, torture, biological experiments, willfully abandoning them, or deliberately exposing them to contagion or infection. This list is a major aha moment, wouldn't you say? The drafters were being incredibly explicit about the acts they were forbidding.
It makes it crystal clear what crosses the line. And once they're no longer combatants, there's an obligation to actually find them and care for them.
Yes, definitely. Article 15 in GCI and 18 in GC2 mandate that parties must search for and collect the wounded, sick, and shipwrecked after combat. They have to be protected from ill treatment or, looting, and adequate care must be ensured. The conventions even allow for local agreements to help get them out of places like besieged areas.
And identifying them is a key part of that process, I imagine.
Absolutely essential. Articles 16 in GCI and 19 in GC2 make it mandatory to record specific details, name, rank, service number, information about their capture or death, things like that. This information has to be forwarded quickly via these things called information bureaus to the power they belong to. It ensures accountability and lets families know what happened.
Okay, moving from the individuals themselves to the places and vehicles used to care for them, hospitals, ships, aircraft. What's the core concept of protection around these? And importantly, how are they supposed to be identified so everyone knows they're off limits?
The main idea here is that medical facilities and transports get this special protected status precisely because of their humanitarian job. They are strictly off limits for attack. And the key to making this protection work is clear identification using specific emblems, symbols established by the conventions. Chapter 3 of GC2, starting around Article 22, focuses specifically on hospital ships.
Right, which says military hospital ships are protected and shouldn't be attacked or captured if they've given notification 10 days beforehand.
Exactly, that prior notification is part of the system. But the protection isn't just for military ships. Articles 24, 25, and 27 of GCCC extend similar protection to hospital ships run by relief societies or even private individuals. That could be from any party or even neutral countries. And it also covers coastal rescue craft. Article 26 makes it clear this applies regardless of the ship's size, its tonnage.
Okay, so they get special status, but what are the rules for these vessels? And can they ever lose that protection?
Oh, they definitely aren't free agents. Articles 29, 30, 31, and 33 of GC2 spell this out quite clearly. They must be used solely for humanitarian purposes, providing relief without any distinction of nationality. They absolutely cannot be used for military purposes or interfere with combat operations. Parties still have rights to control and search them, maybe order them to leave, or even temporarily detain them up to 7 days in really grave circumstances. That's Article 31. And importantly, Article 33 says once a merchant vessel is converted to a hospital ship, it keeps that status for the whole conflict.
And that crucial point about when protection actually stops.
Article 34 of GC2 is very, very clear on this. Protection only ceases if the ship commits acts harmful to the enemy outside its humanitarian duties. And even then, it only stops after a formal warning has been given, a reasonable time allowed for them to comply, and the warning hasn't been heeded. It's a very strict condition, not some easy loophole.
And beyond ships, there's protection for medical transport by air as well.
Yes, medical aircraft are covered. You see that in Article 39 of GC-OSEC and Articles 36 and 39 of GCI. Just like ships, they are not to be attacked while flying at agreed routes, times, and heights. Flights over enemy territory are generally restricted unless it's specifically agreed upon, and they must always obey a summons to land. Article 38 of GC-SOVSE also protects ships that are chartered exclusively just to transport medical equipment.
And the people actually working on these transports and in the facilities.
Chapter 4 of GC-SAGO, articles like 36 and 37, protects the religious, medical, and hospital personnel assigned to care for the wounded, sick, or shipwrecked. They are respected and protected. They cannot be captured while they're performing their duties. If they do fall into enemy hands, they should actually continue their functions as needed and be sent back when they're no longer required.
This brings us perfectly to how all these people, places, and things are identified as being protected. What are the distinctive emblems, and what do we really need to understand about them?
The main thing to grasp is that the conventions designate specific, internationally recognized symbols. These visually signal protected status, creating a clear mark of neutrality and humanitarian purpose. Chapter 7th of GC or 3 and Chapter 6 of GC 7 introduce these emblems.
The Red Cross being the most famous one, of course.
Exactly. The Red Cross on a white background is the primary emblem, a nod to Switzerland historically. But the conventions also explicitly recognize the Red Crescent and the Red Lion and Sun for countries that used the symbols at the time.
And these aren't just symbols, they actually confer protection. How are they used in practice?
Articles 39 through 44 detail this pretty well. The emblem is displayed on flags flown over protected units, on armlets worn by medical and religious personnel, and on their equipment. Personnel wear a stamped, water-resistant armlet, and they have to carry special identity cards with their photo and specifics about their role under the convention. Auxiliary personnel have slightly different armlets, and flags with the emblem can be hoisted over medical units, but only with military consent.
Is there any limitation on using the emblem? I mean, can anyone just slap a red cross on something?
No, and this is a really crucial point. It's addressed in Article 44 of both GCI and 2. Generally speaking, the emblem and associated names like Red Cross are only supposed to be used to indicate or protect the units, personnel, and material covered by the conventions. Now, national Red Cross societies can use a small version for peacetime activities or certain wartime activities that don't confer protection under the convention, like general relief work, away from the fighting. But it's under strict conditions.
Right.
It has to be small, not on armlets or roofs, and clearly not implying protective status. This distinction is absolutely vital to preserve the emblem's protective power and, frankly, prevent misuse.
Okay, let's shift focus slightly to creating safe spaces within conflict zones, these hospital and safety zones. What's the core concept behind these designated areas, and what are the specific conditions needed to set them up?
The essential understanding here is that parties to a conflict can actually agree to create specially protected zones. These are intended as sanctuaries for vulnerable groups, the wounded, sick, elderly, children, new mothers, that sort of thing. This is covered in Article 14 and 15 of the Civilian Convention summary we looked at, and Annex I provides a whole draft agreement laying out the details.
An Annex I lists really detailed conditions for these zones, doesn't it?
Yes, Article 4 of that annex outlines the criteria. They have to be a small portion of territory, relatively thinly populated compared to the accommodation they offer, situated far away from any military objectives or major industrial or administrative sites. And crucially, they shouldn't be located in areas that are strategically important or likely to become important for the conduct of the war.
So definitely not in the middle of a major city or near a key bridge, for example.
Exactly. The conditions are really designed to ensure these zones are genuinely non-strategic targets. Article 5 of Annex I adds more obligations. No military work or production of war material is allowed within the zone, and communication or transport lines within the zone cannot be used for military personnel or material. They have to be kept purely civilian.
What's the process to actually get one recognized by the other side in the conflict?
Well, Article 6 of Annex I requires notification to the adverse party. Once they're notified, the zone is considered constituted. However, Article 8 allows the adverse party to refuse recognition if they think the conditions aren't being met. Or they can demand control by a special commission to verify compliance. And if problems aren't fixed quickly after a commission visit, Article 9 says the adverse party can declare they are no longer bound by the agreement for that specific zone.
And assuming it is recognized, what's the level of protection it gets?
Article 11 of Annex I states it very clearly. Hospital zones shall in no circumstances be the object of attack. They must be protected and respected at all times. Even if the territory becomes occupied, Article 12 says they should continue to be respected and used. Though the occupying power can adapt their purpose as long as the safety of the people inside is absolutely guaranteed.
All right, let's turn now to one of the most detailed sections in these conventions. Prisoners of war, or POWs, covered extensively in GC3. What's the foundational concept here? And what are the absolute core rules regarding their status and treatment right from the moment of capture?
The key thing to grasp here is, first, the really detailed legal definition of who actually qualifies as a prisoner of war, which, as we'll see, is broader than just regular soldiers. And second, the absolute responsibility the capturing power takes on for their humane treatment. The preliminary remarks we looked at note how much this convention was expanded after WWII, specifically to prevent ambiguities that had caused problems.
Okay, so who qualifies under Article 4 of GC3? It's not just soldiers.
Not at all. Article 4 lists several categories. It starts with members of the armed forces, yes, but then significantly extends to militias and volunteer corps, including organized resistance movements. But there's a condition. They have to meet certain criteria, being commanded by a responsible person, having a fixed, distinctive sign visible at a distance, carrying arms openly, and conducting operations according to the laws and customs of war. It also includes regular forces of governments that might not be recognized by the detaining power. And authorized accompanying civilians with ID cards, think war correspondents again. Also, merchant marine and civil aircraft crews. And even, interestingly, inhabitants of non-occupied territory who spontaneously take up arms against an invading force if they carry arms openly and respect the laws of war.
Wow, that's a much more expansive definition than many might think. And once someone is captured under one of these categories, who's actually responsible for them? Is it the soldier who captured them?
No, and Article 12 of GC III is very clear on this. POWs are in the hands of the enemy power, the state, not the individual soldier or unit that captured them. The detaining power, the state, is responsible for their treatment. It also specifies rules if POWs are transferred to another power. That power must also be a party to the convention and willing and able to apply it. And if the receiving power fails in its duties, the original transferring power has an obligation to take steps to correct the situation or even request the prisoners back.
And humane treatment is absolutely mandated.
Absolutely. Article 13 of GC3 states POWs must at all times be humanely treated. It lists unlawful acts causing death or seriously endangering health as serious breaches of the convention. It explicitly prohibits physical mutilation and medical or scientific experiments that aren't justified by the prisoner's medical treatment and in their interest. They must be protected against acts of violence or intimidation, against insults, and against public curiosity. And crucially, reprisals against POWs are expressly prohibited. You can't punish them for something the other side did.
Article 14 also mentions respecting their person and honor and special consideration for women prisoners.
Yes, they retain their full civil capacity as far as captivity allows. And women prisoners must be treated with all the regard due to their sex and, in all cases, benefit from treatment at least as favorable as that granted to men.
What about their identity documents and personal belongings when they're captured?
Article 18 addresses this. POWs should have identity documents or be supplied with them if they don't. Things like badges of rank and nationality, decorations, and items of primarily personal or sentimental value cannot be taken away from them. Money can only be taken by order of an officer, and it must be recorded, a receipt given, and usually credited to an account for the prisoner, as laid out in the financial section later on.
Okay, let's look at the reality of daily life in captivity. What should you, the listener, understand about the rules governing internment itself, the living conditions, and the possibility of labor for prisoners of war?
The main insight here, I think, is the sheer level of detail the conventions go into. They try to ensure minimum standards of human decency, health, and even opportunities for activity while people are confined. Section 2 of GC3 covers internment and the conditions.
Article 21 mentions they can be interned, usually within camp limits, and that close confinement is limited.
Right. Close confinement is restricted and should only be used if essential for health reasons and only for a short time. Article 39 adds a really key point about camp administration. It must be under the authority of a responsible commissioned officer from the regular armed forces of the detaining power. And that officer must have a copy of the convention and ensure their staff know its provisions. The preliminary remarks noted this level of detail was added because, well, the daily lives of prisoners were so heavily dependent on how general rules were actually interpreted by camp commanders.
What about the basic standards for accommodation and essentials like food and clothing?
Well, while the excerpts don't detail everything, the sources confirm that accommodation must meet standards for hygiene and healthfulness and protect prisoners from the climate and, importantly, the effects of war, Article 25. Food rations must be sufficient in quantity, quality, and variety to keep prisoners in good health, Article 26. Clothing, underwear, and footwear must be provided if needed, Article 27. And camps must have canteens where prisoners can buy things like soap, tobacco, and foodstuffs. The profits from the canteen must be used for the benefit of the prisoners, and a committee elected by the prisoners has to be involved in running it, Article 28.
Health and medical care sound like a very significant part of the rules, too.
Absolutely critical. Chapter 3, Article 29 onwards, deals specifically with hygiene and medical attention. This mandates all necessary sanitary measures to ensure cleanliness and healthfulness of camps. Proper toilet facilities separate for women have to be provided. Sufficient water and soap for personal hygiene are required. Adequate infirmaries must be available in every camp. There should be isolation wards for contagious diseases or mental illness. Seriously ill or injured prisoners must be admitted to military or civilian medical units qualified to treat them. Special facilities should be provided for disabled prisoners, and regular medical inspections, at least once a month, are mandatory. That's Article 55, mentioned later under labor.
What about the medical and religious personnel who might be captured alongside the soldiers they were caring for?
Ah, yes. Chapter 4, Article 33 clarifies their special status. They are not considered prisoners of war in the full sense, but they receive at least the benefits and protection of the Convention and must be given all facilities needed to provide medical and spiritual care to the POWs. They should be allowed to continue their functions, preferably for prisoners from their own forces.
And the religious needs of the prisoners themselves are also addressed.
Yes, Articles 36 and 37 ensure freedom for POW ministers of religion to practice freely among their co-religionists. If there are no retained chaplains, the authorities should try to arrange for a minister or, if that's not possible, a qualified layman from the same denomination to visit or be appointed with the approval of the prisoners and the authorities.
And recreation. Even recreation is encouraged. That seems surprising.
It does, doesn't it? But Article 38 mandates that the detaining power should encourage intellectual, educational, and recreational pursuits, sports, and games among prisoners. They should provide adequate premises and equipment. And prisoners must be granted sufficient open space for physical exercise. It acknowledges the need for mental and physical well-being even in captivity.
Okay, let's look at work. Can POWs be forced to work? What are the rules around that?
Section 3, Article 49 onwards covers labor. The detaining power can utilize the labor of prisoners of war who are physically fit, taking their age, sex, rank, and physical aptitude into account. But importantly, national labor laws concerning safety, working hours, and conditions must apply. POWs should receive the same training and protective equipment as nationals doing similar work, and disciplinary measures cannot be used to worsen working conditions.
Are there limitations on the kind of work they could be made to do?
Yes, this is absolutely key. Articles 52 and 53 explicitly prohibit unhealthy or dangerous labor unless the prisoner volunteers. Removing mines is specifically listed as dangerous work. Any work considered humiliating for a member of the detaining power's own forces is also forbidden. The duration of daily labor, including the time for travel to and from work, must not be excessive and should never exceed that permitted for civilian workers in the same district doing the same type of work.
And do they receive pay for this work? What happens if they have an accident while working?
Yes, they are entitled to working pay. Article 54 references Article 62, which is part of the financial section, and sets out how pay rates are determined. If they are injured or fall ill as a result of their work, they must receive all the care their condition requires. The detaining power also has to provide them with a medical certificate so they can make a claim against their home power later on.
Staying connected to family and the outside world must be incredibly important for anyone detained. What does the convention actually say about correspondence and receiving relief packages for prisoners of war?
The core concept here, definitely, is the prisoner's fundamental right to communicate and receive aid, and the corresponding obligation on the detaining power to facilitate this, even with wartime constraints. Section V of GC3 Thread, Article 69 onwards, deals directly with relations with the exterior.
Article 69 requires the detaining power to inform everyone about the measures they're taking for communication. Setting expectations, I suppose.
Exactly. And Article 70 mandates that initial notification right after capture or arrival at a camp. Within 1 week, prisoners must be allowed to send a capture card. There's a model and annex first, directly to their family, and also to the Central Prisoners of War Agency. This card confirms their capture, gives their location, and provides basic health information. These cards are supposed to be transmitted as quickly as possible.
And what about regular mail after that?
Article 71 covers correspondence. Prisoners are allowed to send and receive letters and cards. Now, the detaining power can limit the number sent, but not below 2 letters and 4 cards per month, following the models annexed to the convention. More severe limits on sending mail are only possible if the protecting power agrees it's genuinely in the prisoner's interest, usually because of major difficulties with censorship or translation. Limits on mail received, however, are primarily controlled by the prisoner's home power, though maybe at the detaining power's request. And all mail must be conveyed by the most rapid means available.
What about receiving packages from home or aid organizations?
Articles 72 through 75 cover relief shipments, both individual parcels and collective relief shipments. Things like food, clothing, medical supplies, books, religious items, educational materials are allowed. And, crucially, receiving these shipments does not excuse the detaining power from its own obligations to provide for the prisoners. That's very clear. Limits on shipments are only supposed to happen if there's exceptional strain on transport or communications and should be proposed by the protecting power or aid societies involved. These shipments are also exempt from all import, customs, and other dues, including postal charges normally. Transport costs are generally borne by the powers controlling the territory where transport happens, or shared proportionally based on distance.
Is all this mail, and are these packages subject to censorship? How does that work?
Yes. Article 76 addresses censorship and examination. Correspondence is censored as quickly as possible. Ideally, it should only be done once by the sending state and once by the receiving state. The examination of parcels must not damage the contents and should, whenever possible, be done in the presence of the addressee or their authorized representative. Delivery of mail or parcels cannot be delayed just because of censorship difficulties.
Okay, let's look now at how prisoners interact with the camp authorities, how they can voice complaints, and what happens if they face any disciplinary or judicial action. What's important for you, the listener, to understand about these prisoner-authority relations and judicial matters?
I think the key grasp here is that there are formal channels for prisoners to raise issues. And importantly, significant legal safeguards are built into the conventions for any disciplinary or court proceedings they might face. Section 6 of GC 3rd, starting with Article 78, covers relations with the authorities.
And Article 78 specifically gives them the right to complain.
Exactly. They have the right to make requests to the military authorities holding them regarding their conditions of captivity. More importantly, they have the unrestricted right to apply to the representatives of the protecting power, either directly or through their elected prisoner's representative, to draw attention to issues about their captivity conditions. These complaints can't be limited or punished.
And they can elect their own representatives within the camp.
Yes, Chapter 2, Article 79 onwards details the prisoner's representatives. Except in officer camps, prisoners can freely elect representatives by secret ballot every 6 months. Their role is absolutely vital. They represent the prisoner's interests in dealings with the military authorities, the protecting power, the ICRC, and other aid organizations. They also help with the distribution of collective relief and can assist prisoners with correspondence and legal documents, Articles 80, 81, 77. The authorities must provide them with the necessary facilities to carry out their duties. They can't be punished for just doing their job as a rep.
What happens if a prisoner is accused of breaking a rule or committing an offense? Is there a specific sort of legal code within the convention itself?
Chapter 3, Article 82 onwards, provides a framework for penal and disciplinary sanctions. It's like a brief code of conduct and justice. A key principle found in Article 102 is that prisoners should generally be tried by the same courts and according to the same procedure as members of the detaining power's own armed forces. A crucial protection from Article 87 is that they cannot be sentenced for actions that weren't illegal under the law, either national or international, at the time the act was committed. No retroactive punishment. And if a death sentence is a possibility, Article 100 requires the court to give particular attention to the fact that the accused, not being a national of the detaining power, is not bound to it by any duty of allegiance and is in its power due to circumstances outside their own will.
What sort of safeguards are actually in place during these trials?
Articles 103, 104, 105, and 107 detail quite a few important ones. Investigations and trials must be conducted promptly. Confinement while awaiting trial must be minimized. A critical safeguard in Article 104 is that the protecting power must be notified at least 3 weeks before judicial trial begins, especially if the charge could lead to the death penalty or imprisonment for 2 years or more. This notification has to include specific details about the prisoner, the charge, the court, and the date place of the trial. The prisoner has the absolute right to be assisted by a fellow prisoner, to have qualified legal counsel, either their own choice or provided by the protecting power if necessary to call witnesses, and, if needed, to have the services of a competent interpreter, Article 105. Findings and sentences must also be communicated promptly to the protecting power as well as to the prisoner and their representative, Article 107. And crucially, any appeal periods don't start running until the protecting power has officially received notification of the judgment.
And disciplinary punishment is handled differently from these judicial punishments.
Yes, Article 89 onwards covers disciplinary punishment, which is for less severe offenses against camp rules. The rules limit the maximum duration for any single punishment, usually 30 days. They explicitly forbid certain punishments like collective punishment for individual acts, corporal punishment, imprisonment in premises without daylight, and any form of torture or cruelty. Conditions during disciplinary confinement must still allow for things like daily exercise, at least 1 hour, medical attention upon request, and reading and writing, as well as sending receiving mail, Articles 97, 98.
Escape attempts are, a classic part of wartime stories. How does the convention handle escape? Is it harshly punished?
Articles 91, 92, 93, and 94 address this specifically. And the surprising point for some might be Article 91. Successfully escaped prisoners who are later recaptured are not liable to any punishment just for the previous escape itself. An unsuccessful escape attempt being caught before rejoining their own forces or leaving territory controlled by the enemy makes the prisoner liable only to disciplinary punishment, even if it's a repeated attempt. Article 92. Offenses committed solely to facilitate an escape, provided they didn't involve violence against persons, like theft of civilian clothes or using false papers, usually only result in disciplinary punishment too, Article 93. And people who aid or abet an escape attempt are also only liable to disciplinary punishment on that account, Article 94. There's also a requirement to notify the protecting power if an escapee is recaptured.
Finally, for POWs, how does their captivity actually end? What are the rules for getting them home?
The main thing to grasp here is that the conventions provide specific pathways for ending captivity, especially for the most vulnerable during the hostilities, and then mandate prompt release for everyone once the fighting stops. Part 4 of GC 3rd, Article 109 onwards, covers the termination of captivity.
Article 109 mandates direct repatriation for the seriously wounded and seriously sick.
Correct. Parties are bound to send back these individuals, regardless of their number or rank, as soon as they are medically fit enough to travel. Article 1010 lists detailed categories of who is eligible for this direct repatriation. It includes things like those with incurable conditions whose fitness is gravely diminished, those not expected to recover within a year whose condition requires treatment and whose fitness is gravely diminished, or even those who have recovered but whose mental or physical fitness seems gravely and permanently diminished.
And there's also an option for sending certain prisoners to neutral countries instead of straight home.
Yes, Articles 109 and 110 also outline arrangements that should be made, through agreements with neutral powers, for placing sick and wounded prisoners in those neutral countries if their recovery or health is likely to improve significantly there. This might apply to prisoners whose recovery is expected within a year if treated in a neutral country, or whose health is seriously threatened by continued captivity but might recover in a neutral country. The conditions for their eventual repatriation from the neutral country, or what happens if hostilities end while they are there, are supposed to be agreed upon between the powers concerned.
Can a prisoner who's, say, facing charges or serving a sentence still benefit from these repatriation or neutral accommodation measures?
Article 115 addresses this. Prisoners undergoing a disciplinary punishment cannot be held back from repatriation or accommodation if they are otherwise eligible. Those who are facing judicial prosecution or serving a sentence can potentially benefit from these measures if the detaining power consents, even before their legal process or sentence is fully completed.
And what happens to everyone else when the conflict is finally over?
Article 118 is incredibly clear and non-negotiable on this point. Prisoners of war must be released and repatriated without delay after the cessation of active hostilities. There's an obligation to establish a plan for this repatriation and execute it as soon as possible. Article 117 adds that repatriated persons cannot be employed on active military service afterwards. The costs of repatriation are supposed to be shared equitably between the detaining power and the power the prisoners depend on.
Okay, turning our attention now fully to civilians. The Fourth Geneva Convention, GC the 5th, was a major new development after World War II, wasn't it? What's the core concept behind protecting civilian persons during conflict and occupation, and what are their most basic rights under this convention?
You're right, it was huge. The critical thing to grasp here is that civilians who find themselves in the hands of an enemy power, particularly in occupied territory, also receive extensive legal protection under GC 5th. It places significant limitations on the power holding them. The preliminary remarks we saw really emphasize that the horrific experiences of civilians in World War II made a dedicated civilian convention absolutely necessary. There were gaps in the law before.
So who exactly counts as a protected civilian under Article 4 of GCF?
Article 4 defines protected persons as those who, at a given moment and in any manner whatsoever, find themselves, in case of a conflict or occupation, in the hands of a party to the conflict or occupying power of which they are not nationals. There are some specific exclusions like nationals of a state not bound by the convention, or nationals of a neutral or co-belligerent state if their state has normal diplomatic representation. But that's the foundational definition. People caught in the hands of a power they are not a citizen of.
What basic treatment are they guaranteed under the convention?
Article 27 lays out some fundamental rights. They are entitled in all circumstances to respect for their persons, their honor, their family rights, their religious convictions and practices, and their manners and customs. They must at all times be humanely treated and must be specially protected against all acts of violence or threats thereof, and against insults and public curiosity. And similar to the rules for the wounded and POWs, there are specific acts that are absolutely prohibited against civilians.
Yes. Articles 31 through 34 are absolutely vital here. Article 31 prohibits physical or moral coercion, particularly to obtain information. Article 32 forbids measures causing physical suffering or extermination, including murder, torture, corporal punishment, mutilation, and medical experiments not needed for treatment.
And Article 33 is incredibly important. It prohibits collective penalties and all measures of intimidation or terrorism. Pillage is prohibited. Reprisals against protected persons and their property are prohibited. It emphasizes individual responsibility.
And Article 34
unequivocally states that the taking of hostages is prohibited. These are major, major lines drawn in the sand regarding civilian treatment.
What about civilians' ability to move freely or choose where they live, especially if they find themselves under occupation?
Articles 35, 38, 39, 41, 42, and 43 address movement and residence. Article 35 says protected persons generally have the right to leave the territory at the start of or during a conflict, unless their departure is contrary to national interests. There are procedures for applying. Article 38 says their situation, if they stay, is generally governed by peacetime rules for aliens, but with guaranteed minimum rights if control measures become necessary. It lists some rights, including receiving relief, medical attention, practicing religion, and preferential treatment for vulnerable groups like children under 15, pregnant women, and mothers of young children. They also have the right, under Article 39, to seek paid employment under the same conditions as nationals of the power holding them, subject to security and other convention rules. If security makes control measures absolutely necessary, Article 41 says the only measures allowed are assigned residence or internment. Article 42, these should only be ordered if security genuinely requires it. And a key safeguard from Article 43 is the right for anyone subjected to assigned residence or internment to have that decision reconsidered periodically, at least twice a year, by a competent court or administrative board set up for that purpose.
Occupied territories seem to have particularly detailed rules governing them.
They absolutely do. Section 3 of GC5, starting from Article 47, focuses specifically on occupied territories. A crucial point from Article 47 is that protected persons in occupied territory don't lose their convention benefits just because the occupation changes the territory's institutions or government, or because the occupying power makes agreements with local authorities, or even if the occupying power tries to annex the territory. Their rights remain. And Article 49 contains a very strict prohibition. Individual or mass forcible transfers, as well as deportations of protected persons from occupied territory to the territory of the occupying power or any other country, occupied or not, are prohibited regardless of their motive. Evacuation is only allowed temporarily for safety or imperative military reasons.
What are the main responsibilities of the occupying power towards the civilian population living there?
There are quite a few. Article 51 states they cannot compel protected persons to serve in their armed or auxiliary forces. Any pressure or propaganda aimed at securing voluntary enlistment is prohibited. They can only compel work if the person is over 18, and only for work that is necessary either for the needs of the Army of Occupation, or for public utility services, or for the feeding, shelter, clothing, transportation, or health of the population of the occupied country. Importantly, this work cannot involve taking part in military operations and cannot force civilians to use force to secure the installations where they work. Article 53 prohibits destroying real or personal property unless absolutely required by military operations. The occupying power also has a duty under Article 55 to ensure the food and medical supplies of the population to the fullest extent of the means available to it. They must bring in supplies if local resources are inadequate. They can requisition food and medical supplies from the occupied territory only for their occupation forces and administration personnel, and only after accounting for the needs of the civilian population. Fair value must be paid. They must also facilitate relief consignments intended for the population, Articles 59, 61, 62.
What about legal proceedings against civilians in occupied territory? Are there similar safeguards to those for POWs?
Yes, Articles 64 through 75 provide significant judicial protections, adapting the principles. The penal laws of the occupied territory remain in force unless they threaten the security of the occupying power or the application of the Convention, Article 64. The occupying power can issue its own penal provisions, but these shouldn't be retroactive, Article 65-67. Crucially, Article 71 mandates that no sentence shall be pronounced unless the accused has had a regular trial. They must be promptly informed in writing, in a language they understand, of the charges against them and brought to trial as rapidly as possible. Similar to POWs, Article 71 requires notifying the protecting power of proceedings that could lead to a death sentence or imprisonment for 2 years or more, at least 3 weeks before the trial starts, including all necessary details. The accused has the right to present evidence, call witnesses, and choose their own legal counsel, or have one appointed if they can't afford one. They also have the right to an interpreter, Article 72. Protecting power representatives have the right to attend the trial, unless it must be held in camera for security reasons, but even then, notification is required, Article 74. Notification of judgments must also be sent to the protecting power.
And how are civilians treated if they are detained or interned under these rules?
Article 76 specifies that women must be confined in separate quarters and be under the direct supervision of women. Minors benefit from special treatment provided elsewhere in the Convention. Detainees have the right to receive visits from delegates of the protecting power and the ICRC. They also have the right to receive at least one relief parcel monthly. Article 77 requires that protected persons accused of offenses or serving sentences in occupied territory should be handed over to the authorities of the liberated territory with their records at the close of occupation.
Now, Section 4 of GCIV focuses specifically on civilian internees. What's different or particularly notable about the rules for them?
Right. This section provides a very detailed code specifically for civilian internment, similar in structure to the POW rules in GC 3rd, but tailored for civilians and kept distinct. A key point from Article 84 is that civilian internees must be accommodated and administered separately from prisoners of war and from any other persons deprived of liberty for other reasons. Accommodation standards, Article 85, are similar to those for POWs, focusing on hygiene, healthfulness, protection from climate and war effects, and adequate space. Separate dormitories for men and women are required unless they're family members housed together. Like POWs, canteens must be available where internees can buy goods at local market prices, with profits going to a welfare fund managed by internees, Article 96. Encouraging intellectual, educational, recreational, and sporting activities is mandated, with facilities provided, Article 94. Ensuring the education of children and young people interned is also an obligation, and the text of the convention, its annexes, and any special agreements or regulations must be posted in the internment camp in languages the internees understand, Article 106.
Are civilian internees required to work like some POWs might be?
No, Article 95 is very clear on this. Internees cannot be compelled to perform labor unless they volunteer. Any work that would be prohibited for non-internees under the rules for occupied territories, like military-related work under Article 51, or work that is degrading or humiliating in character, is also forbidden for internees, even if they volunteer. Pay and conditions for voluntary work are regulated.
How do civilian internees stay in touch with the outside world? Is it similar to POWs?
Yes, Articles 107, 108, 112, and 113 cover communication and relief, largely mirroring the POW rules but adapted for civilians. They are allowed to send and receive letters and cards, generally a minimum of 2 letters and 4 cards monthly, Article 107, using the standard models annexed, like those shown in Annex 3. Limits on incoming mail are generally controlled by the power they owe allegiance to. Individual and collective relief shipments are allowed, and again, receiving them doesn't diminish the detaining power's obligations to provide essentials, Article 108. Censorship and examination rules, Article 112, are similar to those for POWs, aiming for speed and minimal interference. And Article 113 requires facilitation for the transmission of legal documents like wills or powers of attorney, usually through the protecting power or central agency.
And what about discipline and escape attempts for civilian internees?
Articles 118 and 121 cover this, again drawing parallels with the POW rules. An escape or attempt to escape results only in disciplinary punishment, even if it's a repeated offense, Article 118. Aiders and abettors also only face disciplinary punishment on that count. Safeguards apply during any disciplinary procedures, ensuring humane treatment and due process. Article 119.
What about transferring internees between camps?
Article 127 mandates that transfers must always be effected humanely. They should generally take place by rail or other transport, providing guarantees of hygiene and health under conditions at least equal to those enjoyed by the detaining power's own forces when changing quarters. The sick and infirm shouldn't be transferred unless their safety absolutely demands it.
And how does internment end for civilians? Are there rules for release or repatriation?
Article 132 requires internees to be released by the detaining power as soon as the reasons which necessitated their internment no longer exist. It also strongly encourages parties to the conflict to conclude agreements during hostilities for the release, repatriation, accommodation in neutral countries, or exchange of certain categories of internees. This specifically mentions children, pregnant women and mothers with infants and young children, wounded and sick, and internees who have been detained for a long time. Finally, mirroring the POW provisions again, GCIV requires parties to establish national information bureaus responsible for collecting and transmitting information about the protected persons in their hands. Article 136. And it establishes a central information agency in a neutral country to centralize and transmit this information. Article 140.
Okay, so we've gone through this incredible detail on who is protected, what their basic rights are, how they should be treated, whether they're wounded, captured soldiers, or civilians caught up in conflict or occupation. But what's the actual enforcement mechanism? What happens if these incredibly detailed rules are violated? And what exactly are these grave breaches we kept hearing mentioned?
This section is absolutely critical, you're right, because it moves from just setting rules on paper to demanding accountability in the real world. The main concept, I think, is the dual obligation placed squarely on states. First, to teach these rules widely, make sure people know them, and second, to actively punish violations. Specifically, they have to identify, search for, and prosecute those responsible for the most serious categories of violations, which are known as grave breaches. This is covered in the chapters often titled Execution of the Convention, or Repression of Abuses and Infractions, across all 4 conventions.
Dissemination, making the rules known, is a key duty mentioned repeatedly, right?
It's mandated right there in articles like 144 and 145 in GC5, and corresponding articles like 4740 back in GC3, 127, 128 in GC3. Parties undertake to disseminate the text of convention as widely as possible in both peacetime and wartime. This explicitly includes incorporating study of the conventions into military training programs and, if possible, civilian instruction. They also have to translate the conventions and communicate to each other their national laws and regulations adopted to ensure its application. The rules aren't meant to be secret. They're meant to be known by everyone, especially those fighting.
And there's a specific obligation to enact penal sanctions, laws to punish violations.
Yes, absolutely. Covered in articles like 146 through 149 in GC3, and the parallel articles in the other 3, 49 to 52 in GC3, 129 to 132 in GC3, parties undertake to enact any legislation necessary to provide effective penal sanctions, especially for persons committing or ordering to be committed any of the grave breaches defined in the convention. Articles 146 GC3-4, 129 GC3, 49 GC3. They also need to take measures necessary for the suppression of all other acts contrary to the convention, not just the grave breaches.
Okay, so let's get specific then. What actually constitutes a grave breach, according to these texts?
Articles 147, GC4, 130, GC3, and 50 GC3 define these explicitly for each convention. These are designated as specific, particularly serious acts committed against persons or property protected by the relevant convention. Looking across the sources we have, the list includes things like willful killing, torture or inhuman treatment, including biological experiments, willfully causing great suffering or serious injury to body or health, extensive destruction and appropriation of property not justified by military necessity and carried out unlawfully and wantonly, that one appears in GC, Psi, and 4, covering medical property and general protected property.
Okay.
Then, specific to POWs and civilians, compelling a prisoner of war or a protected person to serve in the forces of a hostile power, willfully depriving a prisoner of war or a protected person of their rights of fair and regular trial as prescribed in the convention.
That links back to those trial safeguards we discussed.
Exactly, and specific to civilians under GC3. Unlawful deportation or transfer or unlawful confinement of a protected person. And, as we mentioned, the taking of hostages.
That list makes the severity incredibly clear. And there's a specific obligation on states to actually do something about these grave breaches when they occur.
This is perhaps the most powerful obligation in the enforcement section. Articles like 146 in GC 5 and the corresponding ones, 49 GC 3rd, 129 GC 3rd, state that each high contracting party shall be under the obligation to search for persons alleged to have committed or to have ordered to be committed such grave breaches. And this applies regardless of their nationality. They must bring such persons before their own courts. Alternatively, they may also, if they prefer, and in accordance with their own legislation, hand such persons over for trial to another high contracting party concerned, provided that party has made out a prima facie case. The conventions also require that adequate safeguards for a proper trial and defense are provided for the accused in all circumstances. This is really the foundation for universal jurisdiction over grave breaches of the Geneva Conventions.
Wow. There's also a mention of an inquiry procedure in the texts.
Yes, articles like 149 in GC 4V and 53 GC 132 GC 30 provide a mechanism for formal investigations into alleged violations of the conventions initiated at the request of a party to the conflict. It outlines how such inquiries should be conducted, often involving the protecting powers.
Finally, the sources we looked at frequently referenced annexes attached to the conventions. What's the point of these supplementary documents and forms? What should we understand about them?
The key grasped here is simply that the conventions aren't just theoretical principles, they are intended to be applied practically, on the ground, in difficult circumstances. The annexes provide standard models, draft agreements, and frameworks to actually help states implement the rules effectively.
Well, we already discussed Annex I, the draft agreement on hospital and safety zones, which gave us those detailed conditions for setting them up.
Exactly. That provides a ready-made blueprint if parties want to establish such zones. Annex 2 contains draft regulations concerning collective relief for internees. It outlines things like how internee committees should help distribute aid fairly to all internees wherever they might be located, even in hospitals or prisons, Article 1, Annex 2 excerpt. It also says parties should authorize necessary purchases for relief distribution, Article 8. And it emphasizes that the right of prisoners or internees to receive collective relief shouldn't be hindered, for example, before they arrive in a camp or during transfer, Article 9. Then you have Annex 3 and Annex 4, which provides standard communication models. Annex 3 has models for the internment card, letter, and correspondence cards specifically for civilian internees. The excerpt shows examples. And Annex 4 does the same for prisoners of war, providing models for the capture card, correspondence card, and letter. The excerpt shows the kind of required info name, date of birth, rank, service number, address, health status, capture details, and even gives format and size suggestions.
So these annexes are essentially like the practical tools, the forms and templates, provided by the conventions themselves to make compliance easier.
Precisely. They standardize things like the information needed on a capture card or the basic format for letters and cards. This makes it much easier for detaining powers to comply with the communication and information sharing requirements, and for the systems like the central agency to process the information efficiently.
Wow. We have certainly covered a huge amount of ground in this deep dive. It's quite something. From the fundamental scope and the oversight mechanisms, all the way through to the specific, non-negotiable protections for the wounded and sick. The incredibly detailed rules for prisoners of war covering everything from their daily life, their labor, communication, and crucially, their judicial rights. And then the crucial and relatively hard-won protections for civilians, including those really strict limits on occupation powers and the safeguards during internment and legal proceedings.
Looking at the sheer volume and detail of this text, it's just so clear that the international community, right after 1949, was absolutely determined to create robust legal boundaries for conduct in war. There's this intense focus on protecting those no longer participating in hostilities, ensuring their basic dignity and care. And that explicit list of grave breaches, combined with the obligation to search for and prosecute perpetrators, well, it underscores the seriousness with which these rules were intended to be taken.
It really is remarkable, isn't it? The level of detail they attempted to capture, trying to anticipate and regulate so many complex, messy, and difficult wartime situations.
Indeed, and the constant emphasis on disseminating the rules, making sure people know them, alongside that duty to prosecute violations. It just shows these weren't meant to be, purely theoretical ideals locked away in law books. They were intended as known and enforced standards of behavior.
Which brings us to a final thought. Considering how much the world, and frankly the face of conflict itself, have changed since 1949, think new technologies, new forms of warfare, the rise of non-state actors, how well do these foundational rules, as we've explored them directly from these 1949 texts today, truly equip us to protect the victims of war amidst the unique challenges of the 21st century? Something to really think about, perhaps. Thanks for joining us for this deep dive into the Geneva Conventions.